Welcome to all the participants. Today we'll talk something on legal aspects of business. This is in the second trimester of our MBA program at Krista Jayanti Institute of Management. So let us have an introductory session, try to understand today about company law. So brief session, it will be 5 minutes to 7 minutes. So let me take you forward. I'll share my screen and then we'll go ahead with. Hope my screen is visible to you. Give it a full view. Okay, so this is our course for the day. Legal aspects of business. We will cover, like I said, Companies Act 2013. Okay, so it covers a lot of things in that. We have to make it very brief, peacefully for an introduction. If you look into the evolution of company law, before independence, after independence, how things have moved out. If you look at, if you go through the last 3 points, if you go down, Companies Act 1956, what was there before that? You had Indian Companies Act 1913. What, and you can see the predecessors hmm, who have been there before, started with the registration of joint stock companies, 1850, moved down, and then 1956, you had the Companies Act, and then amendments were there. 1956, a lot of the amendments came up, and you had Companies Act 2013. That's where we are. Having said this, 2013, we have had amendments on 2013 also. Why do you require these amendments? Because the world is business world is changing very fast. Hmm? You are not dealing with the same set of technology or operations that you were doing once before, and not dealing with the same type of association or affiliations or business partners or business affiliates ventures that you were doing in the past. So many things have changed. So the law should also be taking into consideration all this. So that's why you find this evolution in the company's law in India. So today we are currently we are talking about Companies Act 2013. So let us look through it very fast. What according to is a company? Will not give much of a definition to it. We'll just understand it as people coming together. They put money. They get what you call shares. They pursue a common goal or the company goal. So that's what a company is. So you when they come together, they put the money. It is called capital, and everybody has some capital or investments in that, and they all try to earn money out of that. So that's what a company is. It works for profit. So what are the characteristics of a company? You can say they have a distinct personality. It's very distinct, separate from a person or an individual. What are the rights of the creditors to recover? Mm, Suppose a creditor gives a loan to the company, he cannot claim it from the person. For example, I am promoter of the company. I have taken a loan from Mr. X. X tomorrow cannot say that I gave the loan to. If it has come to the company account, X cannot claim that money personally from me now. It has to work it out with the company. So creditor's right to recover is with the company only. Mutual agency, see, in case of one shareholder in the company is not liable for the act of the other. Having said this, the cumulative fact is there in the company. So, but we say that there is mutual agency. One person is not liable for the act of the other. Other things, transferability of shares. You can transfer the shares from one individual to another. You don't need the consent of any other person. Limited liability. What do you mean by limited liability? See, liability of a company is limited either by shares or by guarantee. Correct? We'll look into it a little later. So if it is guarantee, it will be stated in the memorandum. If it is limited by shares, it depends upon the uh, pay unpaid amount of shares. So that is how it is limited. That's the exposure or the liability exposure that the company will have. Perpetual succession means what? It goes on, and once formulated, once incorporated, the company runs forever until and unless it is dissolved by the law. Okay. Other properties, management. See, in case of a company, all shareholders does not actively participate. They would have invested their money, but they are not active. So the ownership may be in the hands of the shareholder, but the management will be in the hands of the of selected few called the director board of directors. So how many members in a company? You can distinguish that into various type of companies, but for simplicity, let us compare it with partnership. Minimum members are 2, maximum 50. Public limited, public company, 7, 2, maximum is no limits are there. Private company, 2, maximum 100. One person company, uh, there is only one person in the board. Okay, so these are the type of companies that we talk about. There is a ruling that is always quoted, Solomon versus Solomon and Company, about the independent existence of company. When we talked now, where initially we said the company has got its own existence. It's an entity by itself. So if you are a creditor, you cannot claim it from the person in the company. You have to claim it from the company. So cases in support of that. So it again, you can see the case that we always quote about is Solomon and Solomon 1897. Okay. Limited liability. We already spoke about limited liability by shares, limited liability by guarantee. Okay. Let us proceed further. We'll proceed further. Hmm. Ownership we spoke about now. See, what do you mean by ownership? See, shareholders are the rightful owners of the company. Anybody, even if you have one share, you are the owner of that company in a limited sense. But the directors are appointed, or the board gets appointed. Some ways, manner of appointments are there. So they get appointed and they decide on the policy matters of the company. And these are the people who control or the management that they control the day-to-day affairs of the company. Okay, let us look at it with an example. If you see Tata Consultancy Service, this was taken probably in the month 2025 November sometime. This data, if you look into, um, you look now, probably the percentage shares would have changed. But some months ago, November 2025, if you look at TCS, promoter and promoters group, 71%, 71.76% of the shareholdings they had, and the remaining 28.23 percentage belong to the public by and large. Hmm? And Reliance, if you look into promoters at 49 percentage, public at 50.89 percentage. See, the point is, honors means this, but directors or the people who run the company are limited. They may be run by the promoters, where they might have stake of less than. There are cases where they have less than 20 percentage shareholdings also. Hmm? Or 10 percentage shareholding. It can happen. So what we are trying to say is we are trying to distinguish between shareholders and the real owners and the people who manage or the board members who run the show for the company. So Companies Act 2013. Let us have a comparison with the Act of 1956. So that point of time, 658 section schedules were 14. It was cut down. In 2013, it came down to 470 sections and 7 schedules. Okay. What are the important highlights of Companies Act 2013? You one person company. See, can a single person form a company? Yes. See, the background to it, if you look into, people from abroad or you have been working abroad, For long years, they want to start up. They think, okay, let me mm, uh, come down to India and set up something. Uh, at that point of time, there are struggles. They don't know whom to associate with, how they should be going ahead with. Just hold on. Let's get back to the slide. So you had one person company. What we were talking when they came back to India, wanted to start up. They are literally stranded. They don't know who to associate. At times they get cheated. So then the government thought, why not single person company? So that's a background to it. Maximum number of members. So that was also defined. You are talking about CSR in a bigger way. There are limits to the number of directors in the uh, company. You have something called the independent directors compulsory mandate. You have a mandate on women director in a company, and you have the national company law tribunal being set up. So, Companies Act. What are the other things highlights? Quickly, we will go through dormant, permitting dormant companies, facilitating e-governance, establishing, we already said, and appellant tribunal also, allowing class action suit that we'll just look into, that is giving priority to the shareholders in case of mismanagement or oppressions by the management. So people who have limited shares or people who don't have much say in the running of the company, they shouldn't be taken for a ride. They shouldn't be at a loss. So you have something called class action suit. Mandatory for companies to have at least one resident director. The person should have been in India for at least 182 days in the previous calendar year. Otherwise, they form companies and they are not in India. That's not. At least one resident director should be there. So, if you look at this slide, what we are looking here is on this slide that there are so many amendments that have come to 2013 Act also. You have some amendments in 2015, 2017, 2019, 2020. So depending on the evolving business operations, you find changes, corrections to or amendments to the existing act. So, two things we'll talk about now is corporate governance. First, why corporate governance? It seeks to promote transparency, accountability, and making people responsible for the act. So you have certain high list there. If you look into the points, there persons cannot become director for more than 10 public companies. Otherwise, people at the top, no, who are influential, who are having the acumen, who are having the powers, they become directors in many companies and doesn't work. Just for namesake, you form and then you put the company, you don't look into the affairs of the company and the company goes to, it doesn't do well in the market. That shouldn't be. Appointment of one-third independent directors. So, independent directors, which means people who don't have anything to do with that company, has to be on the board as independent directors. How many? One-third. Directors have been made liable to compensate in case of if they make undue personal gains. See, and the constitution of an audit committee. So these are some of the important highlights when you come to 2013 Act. Why corporate governance? Because the shareholding, because of the what do you call the online platforms that are available, people getting more aware. You find that many people are going into the stock trading. So you have widespread shareholding patterns now. You have changing ownerships. You have many corporate scams. You can even recollect the Satyam scam, which is one of the landmark this thing where many things went wrong at the same time. It's one beautiful case you can look into to understand the various types of loopholes and frauds that can happen in a company. Uh, then significant increase in the remuneration package for the top management has increased drastically, and the expectation of the society from the corporate has also been going up. So if you look at the transparency side, The disclosures, the various documents about the remuneration, the CSR, um, the way things are being disclosed with the SEBI, um, the vigil mechanism policy, or a, a, a way to monitor a auditing policy. So transparency is one key element when it comes to corporate governance. So here you can see some of the key points: improved reporting system, appointment of independent director, audit committee. When you talk about accountability, the duties of the directors, they cannot do whatever they wish. Probably there was a time when they had the freedom to do a lot more, but then we had many scams over the period of time. So the 2013 the act has been a little more scrutiny to that, little more rigid when it comes to the duties of director, and they are more focused. They cannot get through doing odd things or wrongful things, and they cannot what is said in the memorandum only they should be doing. You We spoke about class action suit. The one explanation is there, which means that the shareholders have some right to prevent damages caused by the people who run the show, basically mean the top management. So key managerial persons, the appointment of key managerial persons are required. We'll go into the details when in the following sessions. You have the serious fraud investigation office. You have inside trading prohibition rules governing that. You have secretarial audits to be set up. So these are all basic requirements specified under corporate governance so that people become more accountable. Huh? Okay, going forward, let us look into one person company. As I said, it means one person in general. So one person also means that you don't need an annual general meeting because only one person is there. Hmm? Uh, Residency period in India for incorporating a one person company has been reduced. Earlier it was 182 days. Now it has been brought down to 120 days. One woman director, again, a notable feature in the Companies Act 2013. So a paid up capital of 100 crore plus requires that you should have a woman director. CSR, corporate social responsibility, if you look into the turnover of rupees 1000 crores or more, or it could be a net worth of 500 crores or more, or a net profit of 5 crore or more in the previous financial year, then it is mandate that you should spend at least 2% on CSR activities. And then the National Tribunal law was there, and the Board for Industrial and Financial Reconstruction was put up. So certain powers of the High Court was transferred to the NCLT, which has become more powerful, and you have a speedy way of settling things. Okay. So again, coming to we already spoke about the amendments that came into the Companies Act. So I think, okay, let us look into this. Company law and human rights. Does anything, company law talk anything about human rights? Specifically, no, because they are two different things. You have to, when you talk about human rights, you have to depend on other statute like the Payment of Wages Act, Factories Act. So there are other statutes for that, which is not well integrated with the company law because the provisions are different. Um, the company law, in fact, depends on the other statutes when it comes to human rights. So, with this briefly, and minority shareholders, we already said protection if a company merges with another, acquired by another one. How does it go about? There should be an option for the dissenting shareholder to exit that. He doesn't want to go into the new acquired firm. He should be given a provision to leave that. So these are certain mm, um, aspects when it comes to the company law 2013. So briefly, what did we discuss? We looked into the evolution of Companies Act. We just found some of the key characteristics, highlights of company law 2013, and we said that many amendments have come over a period of time, and we spoke in fact about the governance, corporate governance, transparency, accountability, and responsibility. We talked about one person company. Even a single person can be form a company. We spoke about women directors, one mandate. We spoke about independent directors, one third of them have to be independent directors. We spoke about uh, the CSR activity, corporate social responsibility, which is also a mandate. We spoke about resident director, which has become a mandate. We spoke about the like this slide speaks the protection of minority shareholder. We spoke about um, the let us come back to that. We spoke of the um, if you look into this slide, the key managerial persons, the fraud investigation clause, and secretary, which are all very essential. Looking at the widespread scam that have taken place in the corporate world before this act came into, and again, company law will be evolving. With this short session, let me stop this introductory part. We'll meet again next time. Thank you.